they've grown a lot. I mean, they've been really aligned. I kind of think they're the new truth commissions.
I mean, I must
They
say,
blend it,
Yeah.
They're kind of the truth part and the accountability, and
yeah, I think it would be interesting. I've never studied all of these truth commissions and how they have developed. Although I've known some people, what's my friend's name from South Africa, who sat on a bunch of them around the globe. She got to be
Navi Pillai.
No, it's not Navi.
It's a good guess, though.
That was a good guess. That's why I sort of chuckled there.
Yeah.
But interestingly enough, I think that she was sitting on them as a paid, lawyer participating.
Oh, that's
I don't
interesting.
know.
Yeah.
It just.
Okay. Hey everyone. So I hope you guys all had a great day here at the symposium. This is now our last panel of the day. So our final panel marks the 60th anniversary of the International Convention of the Elimination of All Forms of Racial Discrimination, or for short, the ICERD, which was adopted in 1965 as the first of the UN Human Rights Treaties. From the beginning, the ICRD was not just a statement against racial discrimination, but it also led to the establishment of a myriad of institutional mechanisms designed to give that commitment effect. For example, a monitoring committee, reporting obligations, complaint procedures, and eventually pathways to the International Court of Justice as well. So over 6 decades, those mechanisms have not remained static. They've been tested, expanded and contested as well. State reporting has evolved, individual and interstate communications have emerged, warning procedures have grown in significance, and ICJ engagement under Article 22 has also become increasingly visible as well. So here on the 60th anniversary of the ICRD, this panel gives an opportunity to take stock to assess where the convention and its operative arms have been effective, and where have they struggled, and where they might develop in the years ahead. So we are fortunate to be joined by 3 scholars and practitioners whose work speaks directly to those questions. Professor David King is an associate professor of law at Dublin City University and one of the leading scholars on ICRD and the UN treaty body system. His book, 50 Years on the International Convention on the Elimination of Racial Discrimination, remains the first comprehensive edited collection dedicated to the convention. He has authored 4 books and numerous articles, including award-winning work cited by the UK Supreme Court. He holds degrees from the University College Cork and the Irish Centre for Human Rights as well. Our next panelist, seated on the end, is Professor Margaret Satterthwaite, who is the UN Special Rapporteur on the Independence of Judges and Lawyers and Faculty Director of the Robert and Helen Bernstein Institute for Human Rights here at the NYU School of Law. She also directs the Legal Empowerment and Judicial Independence Clinic here at the law school. She is a scholar and practitioner with decades of experience in international human rights advocacy, and she previously clerked for both the U.S. Court of Appeals for the Ninth Circuit and the International Court of Justice. And our final speaker in the middle is Gay McDougall, who is the former chair and 3-term member of the United Nations Committee on the Elimination of Racial Discrimination. She previously served as the first UN independent expert on minority issues and as executive director of Global Rights. She is currently a senior fellow and distinguished scholar in residence at the Leitner Center for International Law and Justice and the Center for Race, Law, and Justice at Fordham University School of Law. She holds a JD from Yale Law School, an LLM from the London School of Economics, and has received numerous honors, including a MacArthur Fellowship and South Africa's Order of O.R. Tambo. And so with that, I'll leave it to our panelists for this next discussion. Thank you.
Thank you, Richmond, and thank you to all the editors as well of the journal, the JILP Journal. It's an absolute pleasure to be here, so thanks to the organisers. Thanks also to my fellow panellists. It's a privilege to be here on a panel with you to discuss CERD. I thought I'd begin just with a very quick history of the treaty, some of which Richmond sort of covered as well. But when I teach international law as well, we hear about sort of Western origins of international law. I always think CERD is sort of the answer to that. I mean, it's the first of the UN human rights treaties, and it was a treaty very much driven by sort of African and Asian states in the 1960s. It wasn't supposed to be the first. I mean, should have been the ICCPR. I mean, in 1946, the Commission on Human Rights puts forward the idea of a declaration and a treaty, but of course it would take 20 years to get there in terms of the covenants in 1966. CERD would go from sort of zero to treaty in just 5 years. So from February 1960 to its adoption on the 21st of December 1965, with the declaration in the middle in 1963. So it was adopted very quickly, became the first of the UN human rights treaties because of the contributions of African and Asian states who felt that racial discrimination, the elimination of racial discrimination was a priority. It also, as the first of the UN human rights treaties, pioneered the mechanisms. And so that was very much sort of highlighted by the Secretary General at the time, U Thant, the first non-Western Secretary General from Burma, who sort of highlighted the mechanisms that were sort of being implemented, and sort of that response to the UN that it didn't have the mechanisms to deal with complaints such as those put forward, including by civil society organizations in the US, the 1940s and the 1950s, that the UN now had the mechanisms to sort of deal with these complaints at both, I think, from organizations and from states as well. The mechanisms that were introduced by the convention, first of all, it set up the first UN treaty body, the Committee on the Elimination of Racial Discrimination, or CERD, and it also set up the mechanisms which will be familiar to many of you, the state reports, individual complaints, which are optional, interstate cases as well, which were sort of very much dormant for a period of time. I think it's worth also highlighting the difference between CERD and the ICCPR, which will be adopted just 1 year later. The interstate mechanism in CERD is compulsory, whereas it would be optional under the ICCPR, even though it's just a year later. And CERD has an ICJ clause under Article 22, and the ICCPR doesn't have one. So ICCPR is noticeably weaker, even though it's adopted just 1 year later. So those features would become of significance later down the line. In terms of CERD history, I think it's just worth sort of, initially it was seen as an internationalist statement against apartheid and colonialism, and certainly states that ratified it in its early years perceived it as such. But the committee in the 70s and 80s would require all states to report on the different groups that fall under the scope of the convention. That can be contested, but that has clearly evolved. It has evolved to include, I think, minorities. Other groups like indigenous peoples would emerge pretty early on in the 1980s. And then with a focus on indigenous peoples in the 1990s, caste groups would emerge, although that's still contested by India. We still get sort of some contestation around who the groups are, including in interstate cases as well. I think just one or two sort of highlights as well. In addition to CERD pioneered concluding observations, CERD pioneered general recommendations, which are all sort of standard for UN treaty bodies. And CERD also pioneered a mechanism called the Early Warning Urgent Action Mechanism, which perhaps we'll discuss as well. It's not unique to CERD, but it's really the only UN treaty body, I think, that uses it extensively, and certainly in the way that the committee uses it. The last 10 years, I mean, I did, as mentioned in the kind introduction, I mean, I did do an edited collection on CERD, and it was only sort of as we were doing it that we realized that it was the first one, that there hadn't been one. I think it is an under-researched treaty, and we did sort of point that out. 10 years on, 50 to 60th anniversary, which we're highlighting today, I think the profile has been raised, in particular by the interstate cases. Even though these deal with only a sort of certain number of mechanisms, the treaty's become better known, and it has featured not only in cases before CERD, but also in contentious cases before the ICJ, of which there have been 5, and in advisory opinions of the ICJ as well. So situations which have already been mentioned this morning, such as in Israel-Palestine, but also Armenia-Azerbaijan, conflicts in the Gulf, have been litigated under CERD in the past 10 years. So that's a sort of a quick overview of Think of the Treaty as it stands at 60. I have some great experts here. I think I'll turn first to Gay MacDougall, and it's a privilege to share the panel with Gay. Gay is, of course, a CERD member and also a UN Special Rapporteur on Minorities. So I guess the first question to Gay would be your experience of CERD, achievements and challenges perhaps over your time on the committee.
That's a big question. Well, I guess one point I would make, and it's especially since, I look back, I first got on the committee in 1997. And I can say over this period of time that the committee has only been as good at its jobs, with S, as the people who have been elected to sit on it. And that's a very big point. When I got on, there were a lot of sleepers on the committee, a lot of people who have been on the committee since its beginning. And that's taken decades for us to sort of move those people out of the way. So that's one point. It's the experts that are on it. And secondly, I would say that it's interesting that now the prominence of the committee in especially in terms of, well, even your introduction there, little introduction, is seen through the prism of the extent to which state parties have wound up using the mechanism to go to the ICJ, not the core of our work. I think that we have a lot of problems with those cases.
Yeah.
And what it's done to the overall work. But for us, the core of the work is the interaction with state parties. And the difference between being a special rapporteur, which I did also for 6 years, and this is that they come to us. Mm-hmm. And they come to us with their very high-level officials, generally. You know, the Minister of Justice, the Minister maybe of Foreign Affairs, et cetera. So it's a level of engagement, if they want to engage, that is, I think, maybe unique in the panoply of now human rights organizations and how we. But we also have, and increasingly so, these civil society that now come in droves. For some states, it's more people than the state parties said. But they are essential because they drive this interchange. There's no way that we as state parties sitting there looking at what the state has reported to us as their accomplishments in implementing the treaty. There's no way we would have a real sense of what's happening on the ground and where we should intervene without the civil society. I was the rapporteur, that means, leading the discussion, on China for one of its, I won't say it was the only time, but it was, and actually the Chinese delegation was bigger than the CERB members. It was, they came in force. But it was the engagement with civil society in the run-up to that, as I prepared, that tipped me off to the detention camps that had millions of people in them. And it was not expected, I understand that, but when I raised this issue, you could hear a pin drop in the room. And the way you know that you are really on the right course is that they start attacking you personally. And they did. But they also had to back up because then there was a flood of information about them. Before, it wasn't really out there. I didn't uncover it myself, but that means that a lot of people had the information and were not circulating it widely enough. But without civil society, the whole thing would not work, in my view. Now, we have, CERD, I don't know about the other treaty bodies, we have now established a time when civil society can come and make presentations to us on the record in the formal session, so that there's interpretation of their input. And that's been very important, and also elevating their status in the proceedings, as we've also elevated the status of the now National Institutions of Human Rights, which is something that did not exist when I started doing this work. And these are, you know, institutions that have a formal independence from the government, and you know, they vary around the world. Some can actually intervene in litigation. Some can start litigation in their home countries. Some just report on what's happening. All of that is great. But it's an actor in these sessions that wasn't there for us in the beginning. And that's very important as well. And we give them an opportunity to participate equally with the state party in our dialogue. So that's very important. Now, we've all been struggling with what is euphemistically referred to as the liquidity crisis in the UN, which means that lots of governments, but you know, the US is the greatest offender, have not been paying their dues. And it means that all of these approaches to finding the truth and to laying it bare and to then making appropriate recommendations are really being smashed through because we cannot get the money to do them and back them up. And maybe we'll talk about that later because that's a big topic. But it's, you know, at every turn, if you want to talk about what have been the high points, it's been about the staffing levels and the ability to interact with civil society, which has now been made into a problem through the lack of funding. That's what I was saying.
Yeah.
Again, I don't know if that
That's
adds to
really interesting. Yeah, I mean, I think I would just to add to that, it's worth highlighting on China that it hasn't ratified the ICCPR, and of course there's no regional mechanism available there either. So CERD is often the only avenue for certain, I mean, major human rights violations, or rather one of the few in any case, and so it's one of the few treaty bodies which can engage on that question.
And it was our engagement in that led the High Commissioner to then go to China. You know, China kept saying to me, "You've never been there, how would you know?" Well, I had been there actually, but with another hat on. But, so, you know, the answer to that was that the High Commissioner would.
Yeah.
And you know, there's a lot to say about that trip because she didn't follow all of the usual rules to safeguard the integrity of her mission there. And then she took forever to write the report, and she dropped it on her way out of office, literally 15 minutes before her term ended. But I think in that little scenario, you can see how all of the players make a real difference to the work of those of us sitting around the table.
Yeah, thanks. Meg, I'd just like to bring you in as well. I mean, I'm sure you could speak on some of the points about perhaps the liquidity crisis and how it's affecting your mandate, about civil society participation, but as also your most recent report, you know, from 2025, really good thematic report on Indigenous peoples, and I saw it cite CERD in several places, and so just wondered whether you like perhaps speak on some of those aspects.
Sure. Okay. So thank you very much for having me, and thanks to the organizers. I really enjoyed the last panel, and I wish I had been here for the whole day. So how to start this discussion? Maybe just a bit of why I wanted to do this mandate. Would that be helpful? Perhaps? Yeah. Okay. So the Special Rapporteur on the Independence of Judges and Lawyers, I think, has been seen as like a very technical mandate for a long time. It was very focused on kind of terms of office, ensuring that judges were appointed properly, and then the really important meat of defending judges and lawyers against attack. And that came, of course, out of the dirty wars and the creation of the mandate, which came directly out of the dirty wars in Latin America. For me, this mandate was very compelling because I thought there was another aspect to it that was very important, and that was really thinking about what is the purpose of legal systems, and that they are ultimately supposed to be about justice, and that the role of judges and lawyers is ultimately meant to be to advance justice. So that was how the spirit in which I came into the mandate, and thinking about sort of how to look at some of the issues that I felt like had maybe not had as much attention. So the thematic report you mentioned is on the right of Indigenous peoples under international law to have their own justice systems. And it was very interesting to do the research because it became clear very quickly, which I assumed, but you have to do the work, that this right was very well established. If you actually looked at the work of Indigenous scholars, of course, but also of CERD in particular, having said a lot about this and asking states about it over the years and really engaging in difficult questions. And also, really interestingly, CERD having been used as an advocacy location for Indigenous peoples around the world. And that was really very inspiring to me. And so this report ultimately says simply that there is a human right for Indigenous people to have their own justice systems. What was really interesting to me to just critically reflect on this was to see the pushback. And the pushback, interestingly, was not so much about this right, but more why my mandate doing this. And this is from states. I had partnered with a number of Indigenous organizations to do the report, and we had like just an incredible number of consultations. I think we had 13 consultations because it felt important that this report really advanced the right as articulated by Indigenous peoples. And what was interesting to me was this idea that this was like a wacky thing for my mandate to do, and that I should sort of stay in my lane. But I do feel like it was important that it came from this mandate. And I hope that it will be a resource for Indigenous people going forward, but even more that ministries of justice will read it, that judges will read it. And in particular, there are really difficult moments when Indigenous people's justice jurisdiction is being challenged. And so I think hopefully having this to sort of hold on to and hopefully cite to, I hope will be helpful. So that's where I am coming from. One other thing I think I would say is the way that I think thematic rapporteurs have a little bit of flexibility around kind of deciding when we get to work on different issues, I think does allow us to sometimes look at what the treaty bodies are doing and pick up strands that keep appearing to you all speaking now to you as a CERD person, even though you said your mandate is over.
It just ended.
Which is very painful. Okay. And for those of us who wish you could be always on the committee. But sort of looking at the work of treaty bodies and picking up those strands that maybe need more development, and that was kind of how this came about.
Thanks. No, very interesting, yeah. And I think it's interesting as well in the dynamic, and you do see treaty body members who are also special rapporteurs,
yes.
in particular on CERD.
Yes.
I mean, Gay's not the first or the only special rapporteur on minorities who's come onto the committee, but you started with CERD and then became a special rapporteur on minorities. So I think the treaty bodies and the special procedures, the dynamic between them is very interesting, I think. Gay, can I turn a bit just to the general recommendations? I mean, I became interested in CERD through the issue of caste discrimination. In fact, I mean, my PhD started with CERD General Recommendation 29 on dissent, and which is a term, one of the 5 terms in ICERD in the definition of racial discrimination, which the committee interpreted as including caste, and which India has contested for well over 20 years at this point. And so CERD General Recommendations, I think, can be very interesting documents. CERD was the first treaty body to issue a general recommendation on Indigenous peoples. It's been followed by other treaty bodies. It sort of focused, it moved kind of with a focus on groups, maybe a bit less so today, but certainly there was a period of time when it was focusing on groups. I mean, the most recent one is on reparations for the transatlantic slave trade. Now, I've seen a draft. Somebody circulated a draft. I don't know if they were meant to or not, but I've certainly seen it. It looks very interesting. And obviously, reparations is an issue that has moved from perhaps, I don't hesitate to call it the margins, but at least it was in the Durban Declaration, contested. And so, I mean, I suppose on general recommendations overall, and on the general recommendation on reparations, which is not out yet. But your thoughts on that?
Well, yeah, the general recommendations is a way for CERD to, I think other treaty bodies as well, to make a authoritative interpretation of the treaty. And one of the ways that we have used that has been to expand or elaborate on the articulation in Article 1 of who's covered by, our work. What it says in the Black Letter is distinctions with regard to or based on race, color, descent, national or ethnic origin. And we've done a general recommendation on Indigenous peoples. We've done one on descent that specifically included Dalits. It was after the one you studied. And one of I'll come back to that, Roma, and people of African descent, as well as non-citizens. In each category, it's really expanded. It's focused us and expanded our work. And most importantly, it's elevated the situation of people in those groups who've been struggling for visibility. The reason we wound up with Dalits is, I was, when we had the Durban conference on xenophobia, racial discrimination. This was 2001. And I played a central role in planning that. It was really, I would say, one of the high points of my career, although there have been some high points. But, it opened the door to, and sort of invited groups around the world to come forward, and whatever the tagline is against racial discrimination, they could come under that umbrella. And the one group that we were not able to get that recognition for in Durban were Dalits. So after Durban, CERD did a general recommendation on that, and that's why India will not come to yes. Although we have gone a number of times to meet with the permanent representative in Geneva and have had very important shouting matches with him. So we've also done it for Roma. We did it for people of African descent. And non-citizens, which was drafted and adopted, I think that's 30. So what years was that? Anyway, the point is that there is something in the black letter of ICER that tends to confuse people about the coverage of, our coverage with respect to non-citizens. And it wound up being before the ICJ. And caused even more confusion because we disagree with what the ICJ said. But we had a general recommendation that tried to clarify, and I think it did. And so when for economic reasons and whatever, the movement, the grand movement of people from the global south into the north, we were ready, thankfully, to take clear positions on that. And we just adopted at this last session in December a general recommendation on migration and xenophobia, particularly focusing on xenophobia. And we did something unusual. It was the first time that we, as a treaty body, had drafted a general recommendation in collaboration with another treaty body. So you could write a piece on that.
Yeah.
Okay. So the general recommendations have been used in a way that allows us to say, no, this is our beat, and to also say to others, these people have the rights that are secured and to be protected in our convention. But also, we've done a lot of other general recommendations on specific issues. I did one on gender, and that was maybe in 2000. And was harder than I thought it should be. But you learn, live and learn. And we also just recently did one on health, which I thought was a very strong one. And I'm the rapporteur that drafted, is still drafting, the one on reparations.
Yeah, that's GR40.
GR40. And it's gotten a lot of pushback from understandable areas, including the High Commissioner's office, which, but
Interesting.
we should talk about that as well. But, it is, these general recommendations, I mean, in terms of the reparations one, my hope is that it will anchor the calls for reparations that are growing, both inside the UN and around the world, for reparations, and give it an anchor of a legal analysis. I try to respond to the claim by the states that were initial offenders, that they were not doing anything that was illegal or unlawful at the time. And of course, again, we speak to a larger audience, which was saying, this is in the mainstream. This is something that all states must take up. Whether you think you are involved or not, actually you benefited from it. But all states have an obligation under our convention and under customary law to take firm action against or in favor of reparations.
Yeah, thanks. I mean, on the temporal argument, for example, one of the contributors you got was Judge Robinson, the Jamaican judge from the ICJ, who wrote in and offered a contribution, which I read, which I thought was interesting. But I think what your general recommendation will do also which is a sort of a long-running theory of mine, but it'll make it open to litigation, as in the Caribbean states can litigate reparations against the UK or against the Netherlands or against other states under Article 11 before the committee, and potentially under Article 22. Now, whether they want to go there or not is another question,
Yes.
but at the moment it's in a place of discussion and or negotiation, but I think this general recommendation will highlight the potential to litigate the question as well.
Yeah.
At the interstate level. May, can I ask, I mean, we've mentioned sort of, I mean, General Recommendation 30 and Gay is referring to the Qatar versus United Arab Emirates decision, which is unusual in that it came both before a UN treaty body and before the ICJ. CERD issued its decision, which in my view is correctly the correct decision and is perfectly well reasoned. It addresses those aspects of the text. And the text, by the way, is pretty clear that you can't discriminate against a particular nationality. And what was at issue here was the expulsion of Qataris. Yeah. So the ICJ, for all its sort of Vienna Convention approach about text, context, and object and purpose, seemed to ignore Article 1.3. I mean, a lot of ICJ cases, there have been 5 in total. Do you see sort of litigation under the ICJ, litigating CERD before the ICJ as a good step overall, do you think?
I think it's really interesting to think about what they've done under their contentious jurisdiction versus their advisory jurisdiction. On the contentious side, I think it has been very cramped in terms of their reading of CERD itself, and I agree with you. I agree that you're right, both of you, that those decisions were not that helpful, in particular the finding around national origin. And I think that CERD has a much better analysis. However, when we go to the advisory jurisdiction, what you find there is 2 really important cases, right? Both having to do with Israel and Palestine. So the first one finding, of course, that the wall of separation violated CERD, and then the second one more recently finding specifically systemic discrimination under Article 3 of either segregation or apartheid. Now here it's really interesting, right? Because what the ICJ did was to not make clear which one it was finding. It just said there was a violation of Article 3 and then used the language of Article 3, which is segregation or apartheid. This is really important. I mean, this I think is a huge, huge decision. It was, of course, an advisory opinion, but there's so much, I think, that is open now from this decision. And I think it's unfolding, and it will unfold over time. And I was exactly thinking what you were saying about the reparations general recommendation, because there will be many opportunities, I think, to litigate this. And I think that the articulation of systemic discrimination, which is also language that the ICJ uses in the advisory opinion on the occupied Palestinian territory, is one that can really open up the space for talking about reparations. And so I've done a ton of work with Haiti over the years. I worked for the Truth Commission there in 1995. And of course, Haiti's main claim is for reparations from France, because it was forced to pay reparations to France. Yeah. Probably everyone knows this, but I can't resist the moment of education, which is Haiti was, of course, required to pay for not only the property that it reclaimed, but also its own selves by reclaiming themselves as non-territory, as non-property, as individual human beings. So one of its main claims is for reparations. And I feel a ray of hope that I have not had, that there might be a very cognizable international claim here. And it is CARICOM that's been working on this for so long and talking about it and trying to create legal arguments around it. And so I think it's a really exciting set of opportunities down the road. And I think this ICJ right now, because it has so many consequential cases that it's dealing with. But just to mention, of course, Gambia versus Myanmar and South Africa versus Israel, both being about erga omnes obligations under the Genocide Convention. But we know that human rights are erga omnes obligations, so there's so many openings here. And I think that it's a moment when the global majority is going to the ICJ and asking it to do its job and to really say, we actually mean what these human rights treaties say. and not just within territories of individual states, but actually internationally. So I think it's a moment of possibility for global justice. However, I can't resist, being my mandate holder that I am, saying that it's also the moment when these institutions are being attacked. So most obviously the ICC, both the judges and prosecutors having been sanctioned by the US government, which is, we could talk about endlessly, but I will just leave it there. And then also the Russian government having found guilty in absentia 8 ICC judges. And then I think many of us are just waiting for the other shoe to drop vis-a-vis the ICJ. That would be absolutely, absolutely devastating. And I just want to make really clear, completely unacceptable under international law.
Yeah, thanks, Meg. I mean, so yeah, I mean, just to sort of draw on that a bit, I mean, Article 3 of CERD is the first treaty prohibition of apartheid. It was followed by an apartheid convention in the 1970s and the Rome Statute of the ICC, but CERD is the first, and Article 3 is the principal provision on state obligations in relation to apartheid. But it does include, states parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit and eradicate all practices of this nature in territories under their jurisdiction. So that first part, particularly condemn racial segregation and apartheid, means that a breach of Article 3 is not necessarily a finding of apartheid. Now, the committee has, and in a piece I highlighted it. I think I was the first to point it out, really. I said, look, they're saying it's a breach of Article 3, and they're not saying whether that's apartheid or not. They're finding breaches of Article 3 in other scenarios. For example, the treatment of the Roma in the Czech Republic. Nobody is saying, that's not to undermine it, but nobody's saying it's apartheid, but it's clearly. So then the ICJ went and did the same thing. But I mean, the ICJ said it's a breach of Article 3, and they didn't individuate the two terms. So some judges did.
And CERD did under the Palestine.
Well, that's what I was sort of going to ask. So, under the Palestine versus Israel decision, which became the very first treaty body interstate decision.
Yes.
I mean, how do you were part, I know you were part of the preliminary issues, so, and I mean, how did you find the decision overall?
I'm proud about because I thought the jurisdictional issue was a really good one and expansive for CERD's position. But I was very disappointed in a lot of ways about the report coming out of the conciliation. I was disappointed about the procedure as well as the substance there, because the decision of the Conciliation Commission, which caused a lot of bad blood within the CERD, was to wall off the Conciliation Commission as being no longer a part of CERD. So none of the CERD rules about, transparency and engagement, et cetera, could be used to in any way participate before it was announced.
Okay.
Which was, I think there was a lot of back and forth about that. But in fact, the whole thing, the jurisdictional decision, also was the first time that there were such a large number of CERD people that so disagreed that they insisted on publishing a dissent.
Yeah.
So at that, lots of bad blood there, back and forth. But I think that, my view, reading the Conciliation Commission's report, is that they didn't go a lot further than our concluding observations had gone when we had, reviewed CERD and Israel, which we did almost at a parallel point that they were in the Conciliation Commission. So it was very much drawing within the lines of when it could have gone, and done something that really was, also at that same time, we had the council, the Human Rights Council, Commission of Inquiry going, we did have, we had the special rapporteur on Palestine, you know, constantly, you know, saying, you know, better and better things. So it was a time when it would have been very important for CERD to have.
There was an opportunity there that they didn't take. Now, I
Yes.
mean, they also failed in, I think, the legal requirements, which was essentially Palestine was litigating the question of whether it's apartheid or not. We know that apartheid is not
Yes.
defined in CERD, so they had an obligation to, I think, define apartheid and then test whether it
Yes.
is or is not. And they just didn't address that at all. Whatever about the outcome, you might, you know, there might be views on what the outcome might be, but
Right.
if you don't offer the means by which you can test what is before you, specifically being litigated, then it has to be considered a failure in that regard.
Yeah, because it was very specific
Exactly.
in the Palestinian application,
Exactly.
that they wanted the apartheid
decision on
issue.
And you need a definition to decide it. I don't know, Meg, if you've other
No,
thoughts
I
on
can't
that,
add to that.
I mean, on the makeup of the ad hoc, I mean, so just to point out, I mean, the Qatar cases and the Palestine case, they went two different directions. There's two mechanisms there. One is where the parties agree and the commission can be composed of external members, and they were initially in the Qatar cases before they were discontinued. And the other is where they don't agree and CERD appoints from within its own members, and it did that. But it is a separate process. I mean, but CERD did appoint kind of equitable geographic representation and things like that, which were positive, I think. You know, that
Well,
the five
that's a
members
that's a
were,
very facial
yeah, maybe.
evaluate it on, frankly.
I'm clutching at straws, yeah, okay. But I mean, it is, yeah. So can I just ask just on that as well? I mean, follow-up is not part of the text. You know, there's no Article 13 which governs this final steps. Follow-up isn't in there. The committee has thus far shown a willingness for follow-up. I've seen it made a call
We have a
for,
follow-up rapporteur
okay, for the case and for
the conciliation report.
for the conciliation report. And do you see that being, you know, now that, is that a full committee involvement, and do you see that maybe going a bit further overall?
I think so far, the dominant view of the plenary is that the rapporteur is to do follow-up on the report.
Okay.
And, you know, there was an issue, I was at that point still the head of the early warning, and we were doing, you know, early warning decisions on Gaza. And there was an issue as whether or not it's appropriate for the vote,
I know.
you know.
I know.
So it was a very difficult
Yeah.
time, I think.
Okay. I'm aware of time, so we open it up. Will we have a few questions? I can't see around the corner.
Professor Alvarez, yeah.
Yeah.
So, with Dave McDougall on the panel, can't resist, we are in the United States. Can you reflect a little bit on the interplay between civil rights in the United States and the use of CERD? At the beginning, those of us around in the 1990s, this was, the U.S. answer was to join CERD to combat the Soviet Union, complaining that we were still in the Jim Crow era. We've come around to where I think there's considerable resistance in the current employment to much of what CERD has recommended in its own reports over the years to the United States. I myself fear that there might be an exit to CERD, but I also fear that the U.S. will not appoint a successor in terms of the U.S. Can you say a bit about where you see both the past, the civil rights fight in the U.S. and CERD, and the future?
The civil rights in the past?
It-
In the
I
past
think
of
that-
CERD?
No, I'm talking about the interplay between civil rights fights in the United States
Uh.
and using CERD, for example.
Well, you know, I don't think that I got my first appointment based on a notion that, that it would be a crucial step in the Cold War against the Soviet Union. Because I was appointed by Clinton, and I was the first on the committee from the U.S. And there were really no Cold War dynamics, I would say. I had been on the subcommission, which doesn't exist anymore, which was full of Cold War dynamics, and it was a quite disappointing experience. But that was not so much the major tug of war going on CERD. But in recent times, first of all, in the Obama administration, yeah, and in the Biden administration, both engaged well with CERD, not the administration and civil society. Civil society turned out a major group of people, civil rights leaders, community leaders, et cetera, for both the review on, during the Biden administration and Obama. So I think that went, we couldn't have asked for more. Yeah, but it's been a hard time. You know, before, no, in the 90s, I was leading a human rights organization. And we had a whole project on trying to get U.S. civil rights leaders to engage with the UN mechanisms. And, you know, these are, because I come out of the civil rights movement, these are people I knew quite well and worked with over the years. But it was still like pulling teeth for a lot of their own reasons. You know, I'm sure that even with the big engagement that we've had, there would have been other reasons. But, you know, we are so stuck in this country in about civil rights being about litigation, and litigation being about an instant answer, yes or no. And, you know, it's been a problem, not just in terms of engagement with UN mechanisms, but with the whole globe of civil society actors around the world, which is really where human rights is at. So I think that there needs to be, and certainly now, when, you know, why are we running to the courts in the U.S. all the time? Because, you know, especially at this point, when the man owns the courts. So I think that, you know, that it's a major problem, and it's our problem that has led groups to be reluctant to go outside our borders, really, to see what engagement, what transnational human rights engagement could be really about. I wandered on outside of the question, but let me just say that the Trump administration did not put anybody up to be elected at the last election, which was when I intended to make known that I was going to step down. And when he was in office the first time, he bumped me off of CERD. So I think, but actually, that was, them not putting anybody forward was the best outcome.
Yeah.
So, you know, I'm sorry that, you know, that the view from, you know, my position from, you know, which is, I consider my position to be the civil rights movement of now position, won't be heard in CERD. CERD now has a very different makeup. It is majority African now. And that, you know, creates a very different mix in a sense. And in terms of the Western group, or what I say, the so-called Western group, they're now only, as I step down, there are only two. One from Greece and the other one from Turkey, who, why are you in the Western group? But, so, you know, the experience of North America, actually, last time, we didn't have anyone from Latin America. So this is where our constituency is largely, and that's going to have a real impact. We now just elected somebody from Panama, but you know, where's Brazil? You know, where's Colombia? We do have somebody finally from CARICOM. That's their second term. But as I said, first of all, you know, it matters who's on these bodies. And so, you know, I think that it's worth spending time trying to influence that.
Yeah. Any other questions?
Great, thank you very much. Is this working? Can you hear me well?
Yeah.
So there was a very interesting conversation about the interplay between CERT and the ICJ, especially when it came to substantive disagreements. But I was wondering if you can tell us more about how within the committee you saw the drive of maybe certain states to use CERT not so much for substantive litigation, but for jurisdictional litigation, to try to have a basis of jurisdiction to discuss things that maybe were related to racial discrimination, but maybe not. Maybe were related to use of force, aggression, broader questions that nonetheless got kind of grouped between the ICJ because of the use of service jurisdictional basis.
Yeah, there was, is it Armenia versus Azerbaijan, which, you know, I mean, for all the disagreements about CERT, that between CERT and ICE, I thought it was very interesting to see the recognition of CERT as a place where, you know, I mean, ICJ said, oh yeah, CERT applies. This is the first time, you know, that it doesn't, nothing in CERT says we apply to non-combatants only. We apply also to combatants. So you know, I think that opens another door that could be further explored, both by CERT, but also by civil society and states. Yeah.
Yeah. I mean, I would add, I mean, there's been some criticism about this, you know, sort of certification of conflict, as I've heard it called, but I mean, I agree with Gay on this. I mean, much of the criticism I've read about sort of shoehorning these things into CERT don't engage at all with CERT practice, the committee's practice. It's been around for 50 years. The committee has been engaging with armed conflict as it relates to prevention groups for decades.
Yes.
There's rich practice there, so all of these opinion pieces tend not to even mention that. So what are you basing it on? The text of the convention supports it as well. At the time of the drafting, there was specific, if you look at draft Article 1 of the 1963 Declaration, it's about conflict, and conflict is there in the preamble as well, about the ability of racial discrimination to disturb the peace and security of mankind. And that was specifically put in by African states because South Africa was arming itself at the time. So they understood racial discrimination had this conflict component. It's always been there, and it's been there in the practice of the committee since the 70s. So whether that amounts to a breach on the merits in the Armenia case is another question, but in terms of the scope of the convention, it's clearly included. And so I find those commentaries, I don't agree with them. And I would agree with Gay on that.
And with the early warning, urgent action
So
procedure,
much on conflict.
we're constantly talking about conflict
Nate, do you have anything to add?
situations.
No, mic drop. That was a good, I agree with you.
Any other questions?
I have two questions. One is a very practical question, and the other one is much more of a theoretical question. So I hope you'll indulge me in that. But it derives a bit from Jose's question, who's now departing, but the the practical question really is, in this age when we're seeing so much withdrawal from UN mechanisms, and so much, as you highlighted, Professor McDougall, depends on cooperation with states. My very practical question is, if you maybe, and maybe this is a question for Professor Saddleworth as well, examples in which advocates are successfully able to engage with either the treaty bodies or the special procedures when the government is not willing to sort of cooperate in the process. How have you seen advocates effectively still use the mechanisms, even in the absence of government engagement? So that's my super practical question. My more theoretical question is, I think it's really interesting to have this panel focused on CERD, because I think racial justice and human rights have a very complicated and sometimes like tense relationship, to the extent that particularly thinking of Malcolm X and his pursuit of human rights over civil rights, and then the NAACP filing their petition and then being asked to withdraw by Eleanor Roosevelt, right? And so tends to be this like push and pull as it relates to racial justice. And I guess my question is around, to some extent, we see a lot of scholars like Makamotua and B.S. Chemini critiquing human rights as being basically the tool of the oppressor, right? So they map all these ways in which human rights actually perpetuate racial discrimination and racial hierarchy. But on the other hand, we see advocates really engaging these mechanisms as a way to forward racial justice. So I'm thinking of the Ferguson to Geneva campaign and the efforts after George Floyd, despite the dashing of those hopes. And this like theoretical question that I have then is, and maybe that you already answered this to the extent that you say so much depends on the people, but I wonder to what extent you understand the relationship with human rights and racial justice. Is there something inherent within human rights that really prevents it from being an effective tool, much like B.S. Chemini and Matua argue? And where are the openings within that as almost as like a theoretical matter within the framework of human rights?
Well, first of all, there are a lot of entry points for civil society that don't depend on, the state party agreeing or being there, or, our whole early warning urgent action is all about civil society coming to us and saying, something is happening and we need your help. The same with our, we have a procedure for individual complaints, which is not as robust as some of the other treaty bodies, but it's there, and it's used, again, not as robustly, but it's there. Individuals can say, I was treated, with racial overtones or whatever. So I think that we've got a lot of entry points that allow that. But your second point, you want to take that?
No.
Matua is one of my dear friends, by the way.
I mean, I guess one thing I would say is that I do think there is, similar to your panel, there is right now a redefinition, I think, of human rights to put it back in the hands of people and to make it participatory and to make it empowering, and to kind of get the lawyers out of the way a little bit. And I think that's really needed. I think that's really badly needed. And I think in particular, if we're going to engage states that are directly oppressing, harming, using their legal system to harm people, then we have to do that. I think that's really important. So I think that is a process that is also happening in the human rights field. I agree with Gay that there are so many entry points. I mean, for the special procedures on the individual complaint thing, anyone can come directly to me and I can write a communication to their government. Now, a lot of governments don't engage, right? I mean, the U.S. right now, right? Like, I can't get a response out of the U.S.
No, the
I've
US
written it a number of communications. On the other hand, there's so much to be done even without that engagement, right? I mean, sometimes the most impact I have is to get a state very upset because activists at home are using my communication in the press and they're, even filing it in court or whatever, and the state gets extremely upset about that. That's not them really engaging with me in any constructive way. Well, it's a constructive dialogue, but sometimes it's less constructive than one might hope. So I think a lot of this just comes back to advocates just crafting a strategy for themselves and knowing like when can they use the early warning, when can they use the special procedure, when can they bring convince a state to bring a state to state. And I do think that it's ultimately our actions are most effective when they are informed by that kind of like strategic movement level kind of planning for how to utilize us, essentially.
I mean, as much time as I spend sitting in the conference room in Geneva, I spend going around and working with civil society groups all over the world. So, we individually become, once you step into this position, a tool to be used by civil society in helping them to strategize and helping them to figure out how to maneuver public international attention to their problem and to utilize that, to their benefit. So I think that's a very important, I have always taken that as a crucial part of my responsibilities in this position. And as a special rapporteur, I'm sure you do as well. I'm not there for the states. I'd like for them to hear what I'm saying and feel swayed by my arguments. But, personally, if people ask me what are the most important things, when have I felt that I've made the biggest impact, it always starts with engagement with civil society. And sometimes it's not, I remember the first country I went to when I was Special Rapporteur, minorities, was Ethiopia. And I had heard about this and read about this genocidal-like event that happened way in the distant part of, and Amnesty said the same things, but nobody had ever been there. And so I went there, which was not easy. And the first meeting was, I always had this thing of, I'm going to meet with the women first. So, call women together and we sat down one evening around the fireplace. It was just, and they said, no one has ever come to ask us what happened. I mean, that was the moment I said, and I always say that I have no power except the bully pulpit. And so, just by making it clear that I'm going to take your message to, Addis, to the Capitol, and to people who should have been here before, was, I think, it was emblematic of my best possible function. So I think a lot is going on around the globe at the civil society level. I work with lawyers around, that are working hard to find ways to be an effective tool for civil society. So as much as Matua, some of that is about, law professors have to be honorary. Right. But I think that there's no doubt in my mind that human rights is about movements, always has been. And, Eleanor Roosevelt, of course, winds up getting the commendation, but at the same time, she was trying to shut down the NAACP. And, you know, now we all know it. But you know, as I said, my students who come to help me, and they're just, oh, you know, I don't want to do anything wrong. I say, let that just roll off your back, because that's what being a human rights lawyer is about. You're going to go out there, you're going to offend somebody, you're going to do your best. And, you know, I still think that lawyers have the possibilities of serving these higher goals of movements. So, you know.
Okay, I think that's the right line to leave it on. So thanks, everybody.